Okay, so today we're going to get into a huge one. We're talking about the landmark Supreme Court case that basically put the entire NCAA model of amateurism on trial. Yep, this is the story of Alston versus the NCAA, a case that really shook the foundations of the billion-dollar business of college sports. Let's get right into it.
So if you really want to get what's at stake here, you just have to look at the numbers, and this is a big one. $1.1 billion. That's how much money the NCAA rakes in every year just for the March Madness TV rights. I mean, that is a mind-boggling number, and it's right at the very center of this whole fight.
You see, on one hand, you have the NCAA's official mission statement. They talk about maintaining a clear line between intercollegiate athletics and professional sports. Okay, sounds good. But then you look at the reality, and it's a multi-billion-dollar machine running on the work of student athletes. So this case basically forced the courts to ask the question we're all thinking. How can you possibly call it amateurism when that much money is flying around?
All right, Section 1, a billion-dollar contradiction. So let's dig into this tension between what the NCAA says and what the financial reality actually is. So the NCAA's entire legal strategy, their whole argument, really hung on this one single word, amateurism. Their definition seems simple enough, right? Student athletes just can't be paid for their athletic skill. You play, you don't get a paycheck. Seems pretty black and white. But as the court was about to find out, it's not simple at all.
Because it turns out that simple definition was kind of a mess, thanks to the NCAA's own rulebook. I mean, it's just full of exceptions. The court found that athletes were already getting things like Visa gift cards for how they performed. Thousands of dollars from funds that could be used for, well, almost anything. Car repairs, family expenses, even parking tickets. On top of that, cash stipends with no strings attached, unlimited food. So that whole idea of not getting paid, yeah, that line was already so blurry you could barely see it.
Okay, so you've got this major conflict between the rules and reality. Where does a fight like this end up? Well, it lands in the legal world, specifically the antitrust arena.
So the weapon the athletes used was the Sherman Antitrust Act. Now, this is a law that goes all the way back to 1890, and it was created to stop companies from getting together and, colluding to rig the market and kill competition. And when you think about what the NCAA is, it's basically a giant agreement between a bunch of schools that are supposed to be competing with each other. They're all agreeing on the rules, including how much or how little athletes can be compensated. So yeah, that falls right into what this law is all about.
So really, the whole case boils down to one central question. Are all these schools, by working together through the NCAA, basically running an illegal price-fixing scheme on the labor market for student athletes? I mean, by all agreeing, hey, we're not going to pay our players beyond this point, are they breaking the law? That's the heart of it.
And this is where we get one of the greatest lines in modern legal history. Seriously, the lower court had already looked at all the facts and sided with the athletes. So for the appeals court to reverse that decision, the original ruling would have to be, well, let me just quote it, wrong with the force of a 5-week-old unrefrigerated dead fish. No, I'm not making that up. That means the NCAA wasn't just facing an uphill battle. They were trying to climb Mount Everest in flip-flops.
So how does a court figure this out? They use a legal test called the rule of reason. And you can pretty much think of it as a 3-part gauntlet that the NCAA's rules had to run and survive to be considered legal.
And here's how that gauntlet works. It's kind of like a legal tennis match. First, the ball is in the athlete's court. They have to prove the NCAA's rules actually hurt competition. If they do that, then the ball goes over to the NCAA side. They get a chance to argue that, no, actually, our rules have a good reason to exist. They have a pro-competitive justification. And if the court buys that, the ball goes back to the athletes for the final shot. They have to show there's a different way to do it, a less restrictive alternative that still gets the job done. All right, so step 1. This was, let's be honest, a total slam dunk for the athletes. The court looked at it and basically said, yeah. Of course, a rule where all the buyers, the schools, get together and agree not to pay the sellers, the athletes, more than a certain amount is anti-competitive. That's pretty much the definition of price fixing. Easy peasy.
Okay, so on to step 2. Now it's the NCAA's turn to defend themselves. And their whole argument was this. These rules are essential to preserve amateurism. And, they claim, amateurism is what makes college sports different from the pros. It gives fans a different product to choose from. Basically, their argument is, people only watch college sports because the players aren't getting paid like pros.
It's a nice theory, but the facts just didn't hold up. See, back in 2015, the NCAA had already dipped its toe in these waters. They started allowing schools to give athletes small stipends to cover the cost of attendance.
So, according to the NCAA's logic, fan interest should have gone down, right? Well, what actually happened? Revenue for the big conferences went up by $300 million in just 1 year. So much for that argument.
So, because the evidence didn't support the NCAA's claim, the court did something really smart. It split the difference. It basically said, okay, NCAA, you can keep your rules that ban straight-up professional-style salaries. We get that. That keeps things different from the pros. But the court said you have zero justification for limiting benefits that are actually related to education. If anything, giving a student-athlete a laptop or tutoring only makes them more of a student. And that discovery led the court right to the final step, Step 3. They found that, yes, there is a less restrictive alternative. The NCAA can still keep its special amateur brand, but it can do it while letting schools compete for athletes by offering them unlimited education-related benefits. We're talking about things like laptops, science equipment, free tutoring, help with studying abroad, even things like paid internships after you're done playing, or scholarships to go to grad school.
So the NCAA ran the gauntlet, and they didn't make it through unscathed. And that brings us to Section 4, the court's final ruling. This is what changed everything.
So here's how it all shook out. The court's final order was pretty clear. What changed? The NCAA is now forbidden from capping any of those education-related benefits we just talked about. What stayed the same? They can still stop schools from just handing out cash payments that look like pro salaries. But here's a really crucial part. The court also said individual conferences, like the SEC or the Big Ten, can set their own limits on benefits. And that, right there, potentially opened up a whole new world of competition.
All right, final section. College sports, what's next? Because look, this ruling was a huge win for the athletes, for sure. But the story doesn't stop there. In fact, some of the most powerful stuff came from the commentary the judges added to the decision, a really stinging critique of the whole system. I mean, listen to this. In a separate opinion, one of the judges just came out swinging. He said the way student-athletes are treated isn't because of a free market. No. He said, and I'm quoting, it's the result of a cartel of buyers acting in concert to artificially depress the price. A cartel. That is some seriously strong language. He's calling the schools a cartel that's working together to keep athlete pay down. You just don't hear a federal judge talk like that every day.
And he didn't stop there. The same judge then quoted a line from Charles Dickens, saying that if this is how the law works, well, the law is a idiot. His point was that even with this ruling, the law still isn't doing enough to protect the athletes. He's basically saying that the whole idea of letting this system exist at all is just fundamentally broken.
And that's really where this leaves us. The Alston case didn't just chip away at the NCAA's model of amateurism. It took a sledgehammer to the foundation. It forced a door open that can't be closed. But with billions and billions of dollars in play, and these huge questions about what's fair still hanging in the air, you know this fight is not over, not by a long shot. So the real question now is, who's going to make the next move?